My name's Lucy England. I'm a partner in our travel team here at Fox Williams, and it's great that you've been able to join us for our latest travel webinar. As some of you may know, we've been doing a back to basics type seminar. So this one is on data protection, and it's not just the basics, but it's an update on where we're at in the UK following Brexit. Which obviously will affect most businesses with data transfers now internationally. I won't say any more. I will hand over to Nigel, who will introduce the team and talk you through today's webinar. Thanks, Nigel.
Thanks very much, Lucy, and good morning and welcome, and thank you for joining us for this Fox Williams Data Protection Refresher webinar. It's hard to believe that it's more than 4 years since the GDPR came into force across Europe. Of course, we in the UK have since left the EU, but we have incorporated the GDPR into our law. So at least for the time being, we have pretty much the same rules as in the EU. So my name is Nigel Miller, and I'm one of the partners in our tech and data team. And I'm very pleased to be joined by my colleagues, Kolvin and Prachi Vasisht. And here's what we're going to be covering briefly today. I'm going to kick off with a high-level refresher on some of the basics of GDPR. Then Prachi's going to look at international transfers, and in particular the new EU and UK data transfer agreements. And then Kolvin will look at recent enforcement actions by the regulators and what lessons we can learn from those. So there's a lot of detail on each of these issues. Within the hour, we're going to keep things pretty high level. By all means, please submit questions on the chat as we go along. We're going to do our best to answer, but we do have quite a large number of people on the call, so we probably won't get time to deal with them all. But please do contact us directly afterwards by email or otherwise if you need any more information or help. And we'll be more than happy to respond in the coming days. So this webinar is being recorded, and we will circulate a copy of the slides and a link to the recording afterwards. So there's no need to try and scribble notes as we go along if you don't want to. So turning to the data protection refresher, I propose to run through, first of all, the main themes of the GDPR. So it came into force in data protection laws first happened in 1984 and been pretty much largely unchanged since 1998. So they became very out of date, predating the internet, mobile data, social media, AI, and generally the exponential growth of data. So after many years of wrangling, the EU finally introduced the GDPR, which came into force in May 2018. So many of the principles in the GDPR are the same or similar as under the old law, but there's also significant changes, and generally the law is much more onerous and bureaucratic. So what we're going to look at is the core principles, being able to show that you have at least one of a number of legal grounds for processing personal data, keeping records, allowing considerable control and extended rights for data subjects, and of course a much higher risk if you get things wrong because of the potential for eye-watering fines. So it's not for the faint-hearted. Since Brexit, it's also been a bit more complicated because we've now got the UK GDPR and the EU GDPR, and in the UK we also have the Data Protection Act. So that needs to be read alongside the GDPR. And just to keep you on your toes, there's currently a government proposal to introduce a data protection and digital information bill, which will modify the UK GDPR to some extent. So we need to be familiar with both the EU position and also the developing UK position. So looking first of all then at the general principles set out on this slide. The main point, I suppose, to think about it is that the GDPR only applies to information about a person who can be identified from that information. So that's known as personal data. but it's quite broad. It covers obvious things like name and address, but also email addresses, and also online identifiers such as IP address, cookie identifiers and the like. So pretty broad. We also have what's called special categories of data, what used to be known as sensitive personal data, things like racial or ethnic origin, political opinions, religious beliefs, health data, or data relating to sex life or sexual orientation are special category or sensitive personal data. So on the slide, you can see basically what are the 6 data protection principles. Lawful, fair and transparent. Transparency is a key element. We'll look at that. Collecting data only for limited purposes. Minimization, only having the data that's necessary, keeping it accurate and up to date. Storage limitation, only keeping it for no longer than is necessary, meaning you have to have a retention policy in place. And integrity and confidentiality, which is around data security. So if there's only one rule in data protection, it's don't lose the data. As the ICO said, there's no data privacy without data security. So data security is quite a big one, and something we'll look at again a bit later. So then there's the accountability principle as well, which sits on top, and more about that in a moment. So on this slide, we're looking at the legal basis for processing. So we just touched on what are the data protection principles of good data management. The next central point is that you can't process data unless you have a legal basis for the processing. And you have to satisfy at least one of the conditions for processing. So the main ones are, as I think everyone knows, you can process data where you have the consent of the data subject, or the big one is where there's a legitimate interest for the processing. So as regards consent, first of all, well, many businesses think that you need consent to process personal data, but it is actually only one of the possible grounds, and in many cases, it's not the most appropriate ground, and it's quite hard to get, and often it's really the one to avoid unless none of the other grounds are going to apply. Under GDPR, consent is a much stricter requirement than it used to be. It can no longer be implied. It needs to be given by a clear affirmative action. Silence or pre-ticked boxes or inactivity do not establish consent. Also, consent needs to be freely given. So in the context, for example, of the relationship between employers and employees, consent is usually regarded as invalid because of the imbalance in the relationship. It's regarded as not really being a free choice. So in many cases, consent's not the ideal one to rely on. Also, it can be refused, or even if given, the consent can later be withdrawn. So that would then leave you without a legal basis for processing the data, which could be problematic. So next slide, please. Because of the difficulty with getting consent, always good idea to consider other grounds on which to justify the processing. That might be because you have a contract with the individual and you need to process their data to perform that contract, or maybe you've got a legal obligation in certain areas, for example, anti-money laundering or compliance with regulations. And then we have the big one, which is legitimate interest. If you can say that the processing is necessary for genuine and legitimate interests, and that those interests are not outweighed by any potential risk or harm to the individual, then you can justify the processing on this ground of legitimate interests. So it really involves a careful assessment to balance the interests of the business or other party as against the potential risks and harms to the individuals. One factor is always to what extent would the individual expect that you would do with their information. If it's something surprising that they wouldn't expect, then it may not satisfy the legitimate interests balance. Because of this balancing test, the regulators recommend that when you rely on legitimate interests, you conduct what's called a legitimate interests assessment and document your conclusions. Not always done, but probably a good idea to do in cases of where there's particular risks in the processing. So there are a number of areas or examples given in the GDPR where legitimate interests could apply. So for example, marketing, business development is a clear legitimate interest, fraud prevention, cybersecurity, as well as things like transfers within the group. So they're all areas where you can reasonably justify the processing on the basis of legitimate interests. Next slide, please. So in relation to the special categories of data, sensitive personal data that I mentioned, you need an additional ground in addition to the ones we've been talking about. That could be explicit consent, or in the field of employment, where the employer has a legal obligation, or where you have to process the data for the establishment or defense of legal claims. Again, so for special category data, you need that additional ground. Next slide, please. So I mentioned briefly the accountability principles, a little bit difficult to get hold of what that actually means, but in essence, in addition to all the other specific obligations, you've got to be able to demonstrate compliance. There are a number of aspects to that. Record keeping. Organizations have an obligation to keep quite extensive records around their data processing. Many organizations have an obligation to appoint a data protection officer, which is a formal role. And if you don't have an obligation to appoint one, then often it's a good idea to do so anyway, perhaps with a slightly different title. In some scenarios, there's an obligation to carry out what's called a data protection impact assessment, DPIA, which is basically a risk assessment, particularly in relation to the use of new technologies or higher risk data processing. And again, as part of the accountability sort of framework, there's a concept of privacy by design and default, basically where you're introducing new technologies. The idea is that you build in privacy and data protection as part of the design of the systems, not something that you sort of tack on at the end. So there are a number of elements to that accountability principle. So that's a very quick look at the data protection principles, including accountability, the various legal grounds for processing, such as consent and legitimate interests. Now turning to the next central pillar of the GDPR, which is to give data subjects a large degree of control over their data by giving them a number of rights as to how their data is to be used. First of all is transparency. The GDPR imposes an obligation to be completely transparent about how someone's data is going to be used and provide quite extensive information. It's something that Kolvin is going to be looking at a bit further in a moment, a bit later on. Next slide, please. So perhaps the most used and most controversial of the data subject rights is the right of access to data, also known as data subject access right, or DSAR. So it's interesting to note that in the last year or so, the ICO has reported that 46% of complaints that the ICO received in respect of general non-compliance with the GDPR were to do with this right of access, or DSAR. It was intended to allow individuals to check on what information an organization holds about them and how it's being used and that it's accurate. But in a classic case of unintended consequences, the GDPR has given rise to the weaponization of this request, and it's frequently being used as a form of pre-litigation disclosure, particularly in HR disputes. So people looking to find out what information an organization has about them, often used as a sort of prelude to some sort of dispute. And responding to these DSARs can be major time and cost overhead for organizations and highly disruptive. So one of the more contentious aspects is around the time frame for responding. The basic rule is that you have to respond to data subject requests within, at the latest, within 1 month. But the controversial bit is that this can be extended by a further 2 months to make 3 months if the request is complex or you've received a number of requests from the individual. So in practice, where a DSAR involves quite a lot of information, organizations tend to rely on this complexity ground, which can be quite controversial because they rely on it, but it doesn't necessarily always apply. The ICO says it shouldn't be used except in exceptional cases. And the fact that there is a lot of data to go through and to disclose, or that it's buried in emails and so on, does not necessarily make it complex. So it's one of the more difficult areas. In some cases, you can actually refuse to respond to subject access request where it is what's called manifestly unfounded or excessive, which means that basically the right to a data subject access is being abused. The individual is not really intending to get to their data. They have other motives, for example, to cause harm or harass an organization. So there are some limited grounds on which you could refuse. A couple of other rights mentioned here: the right to rectification. If the data is inaccurate or incomplete, you can require an organization to correct it. The right to object. There's always a right to object to direct marketing, for example, to opt out, or to object to legitimate interests if you contest those, the organization's right to process data on the basis of legitimate interests. There's a particular right in relation to automated decision making. So basically, you can't process data which could have significant impact on a person or a legal effect on a person without human interaction, if they object to it, unless subject to certain limited grounds, such as where it's necessary for the purposes of a contract. So automated decision making, such as in the field of recruitment, needs to be handled sensitively. Looking at just briefly a few of the additional rights, data portability was a new idea, the right for people to receive their data in electronic form so that they could port it over to another service provider. The right to be forgotten, or the right of erasure, not to be confused with the right to be forgotten that was introduced in a case involving Google, where you have the right to have your Google search results removed. So this is the right to have your data erased if there's no legal basis for the organization to hold it, or they maybe were processing it unlawfully. Next slide, please. Just jogging back to the DSARs and data subject access requests, just to mention there are a number of exemptions that apply here, and this can be something that adds to the complexity. It's not the case that all information needs to be provided. Often there are exemptions that one can rely on. Legal professional privilege, for example, or intentions in relation to negotiations. Perhaps the most thorny one is the question of data relating to other people. So if you're responding to a DSAR, it would be problematic if in the course of that you provide information about someone else. So there's often a bit of a balancing exercise to be done here about whether you should provide that information anyway, or redact it or remove it from the information being provided. And it's a little bit complex, that it turns on whether you have the other party's consent to provide the information, or if you should provide it anyway without that consent. And there are a number of considerations to be taken into account, but that's certainly something that can add to complexity if one person's data is very much mixed up with another person's information. You don't want to fall foul of the legislation by providing that other person's information to someone else without having a good legal basis for it. Next slide, please. So that's a brief look at data subject rights. Finally, to have a look at the important area of where you engage a third-party data processor. So the GDPR creates a couple of specific roles. Where you process data, you may be either a controller or possibly a joint controller with someone else, or a processor. So we've got these two roles, basically, of a controller and a processor. In brief, the controller is the owner of the data that makes the decisions about what to do with it. And the processor is typically a service provider who processes data on behalf of the controller. So they don't make decisions around it, decide what to do, but they just provide a service to the controller. So it might be where you have a service provider, or you're using software as a service and the data is being hosted or in some way processed on your behalf by a vendor or service provider. The key point here is that where you use a processor, you need to have a written contract in place, and the GDPR sets out the terms that need to be included in that contract as a minimum. So, for example, contracts with processors have to include specific terms regarding processing only in accordance with the controller's instructions, obligations on the processor around confidentiality, obligations in respect of data security, an obligation on the processor to help with data subject rights, and what happens at the end of the contract in terms of the return or deletion of the data, and other provisions like audit and inspection. Also there's an important provision around the extent to which the processor can subcontract their obligations to a subcontractor or sub-processor with consent or without consent, and the need for the processor to have a contract with their subcontractors in place so that there's a chain of obligations. So there's quite a lot involved in those contracts. It's something that is very much day-to-day requirements of data protection. And generally where you deal with EU regulated entities, their sort of standard conditions will usually provide generally quite one-sided data processing agreements. But if you deal with maybe less sophisticated service providers or service providers from outside of the EU, they may not have those obligations in their standard contracts. So as a controller, it will be very much up to you to make sure that those contracts are in place. And one of the more difficult areas is often around the liability of the processor for the processing and the extent of their liability for that, bearing in mind the potential liabilities that arise under GDPR. So if something goes wrong, and the potential for fines. So there's often a little bit of quite a discussion around liability of processors in those contracts. So that's a very quick look at the basic principles as a refresher on GDPR. I'm now going to hand over to Prachi, who's going to talk about more specifically the rules on international transfers of data. Thank you. Over to Prachi.
Thank you, Nigel. So the UK and European data protection regimes have had developments due to Brexit, and transfer mechanisms in particular have been a tricky area. So most data can flow freely between the EEA and the UK, but where a party transfers personal data to any third country, which is any country or territory outside of the UK or EEA, this is considered a restricted transfer, and both UK and EU GDPR set out requirements that must be fulfilled to give effect to such transfers. But firstly, what is considered a transfer? It is important to note that a number of scenarios can be transfers for the purposes of UK and EU GDPR. Transfers are not limited to just sending data to another party in a third country, for example, via email. If personal data is being transmitted or otherwise made available or accessible in another entity outside of the UK or EEA, this may be considered a restricted transfer. And restricted transfers can take place in the course of providing your services or products, or in the course of undertaking your internal business and administrative functions. So, for example, being based in the UK, if you're booking a holiday for your customers in a third country, say the US, South Africa, Mexico, and provide the personal data of such customers to the hotels at the destination, this will be considered a restricted transfer. And even though this was made in order to provide services which the customer had requested. If you send data or make it available for any of your suppliers based in a third country so that you can perform any of the functions which will enable you to provide your services, for example, payment processing services, this will also be considered a restricted transfer. And similarly, if one of your suppliers or your workers or contractors of one of your suppliers are based in a third country, and they access the personal data held by you in the UK, for example, via remote access for maintenance and other IT services, this may also be a restricted transfer. Another important thing to note is that when we refer to another entity, we refer to any organization which is legally distinct from your organization, even if it is within the same group of companies. As such, transferring or making data available to another company within your group in a third country, for example, for central payroll or HR services, will also be a restricted transfer. Moving to a key distinction, if personal data is only passing through a third country, but the transfer is actually from, say, one UK organization to another, then this will not be a restricted transfer. So for example, if personal data is being transferred from one controller in the UK to the other via a server in the US, but it is not intended that such personal data will be accessed or processed in any way while it is in the US, this will not be a restricted transfer. And so restricted transfers may occur in your operations in more ways than you may have originally anticipated. So how to make legally compliant restricted transfers? Under the UK and the EU GDPR, restricted transfers can be made pursuant to a derogation, or to a country which is recognized as having an adequate level of data protection by the UK government or the European Commission as relevant, or by putting in place appropriate safeguards and ensuring enforceable rights and effective legal remedies are available for data subjects. Today, we will be discussing one of the most common appropriate safeguards used to legitimize such transfers, which are the European Standard Contractual Clauses and the International Data Transfer Agreement and the UK Addendum. Next slide, please. So firstly, the EUSCs are the ideal transfer mechanism to use for the restricted transfers to which only the EU GDPR applies. However, currently there are different versions. The original set of EUSCs, which were adopted by the European Commission, were replaced last year by a new set on the 4th June 2021. But being adopted after Brexit, they're not valid for restricted transfers to which the UK GDPR applies. The new EUSCs took effect on the 27th of June 2021, and the old EUSCs were repealed as of 27 September 2021. The new EUSCs are an improvement, but they do have some limitations that parties using these must be aware of. So the EUSCs may be used to cover transfers pursuant to only 4 types of data relationships, i.e. controller to controller, controller to processor, processor to sub-processor, and processor to controller. And so all possible scenarios are still not covered. For example, a processor transferring data to another processor who isn't a sub-processor and may have been appointed by an instructing controller separately is not covered. So for example, if a third-party reservation management system makes a restricted transfer of any customer data of its client to a third-party loyalty program operator also used by that client, the EUSCs cannot be used to cover such transfers. The EUSCs are also not suitable for restricted transfers to data recipients who are directly subject to the EU GDPR due to its extraterritorial application, and determining the applicability of the EU or UK regimes can be a tricky point for the parties. But for some time, parties whose processing of data was subject to both the GDPRs relied on the EUSCs only, and the UK did not have its own transfer mechanism documents, which parties subject to the UK GDPR could adopt. But finally, on 21st March 2022, the new IDTA and the UK addendum came into force to be used for transfers of UK personal data to third countries. Next slide, please. So the IDTA is the UK's equivalent to the EU SECs and provides an appropriate safeguard for transfers to which only the UK GDPR applies. The IDTA is generally being viewed as a more flexible and workable document as compared to the EU SECs, but it also has some limitations. The IDTA does not contain provisions to address the requirements of Article 28 or the data processing terms when one of the parties is a processor, while the EU SECs deal with this. And so when using the IDTA with processors, parties will need to put in place separate data processing terms. Next slide, please. The International Data Transfer Addendum, or the UK Addendum, is another document published by the ICO to cover restricted transfers. This document will append to the EU SECs and make them work for the transfer of data to which the UK GDPR applies, along with the EU GDPR. And so the use of the EU SECs with the UK Addendum is most likely to become the most preferred transfer mechanism going forward. However, since the UK Addendum can only be used with the new EU SECs, the limitations of the new EU SECs mentioned above will be applicable here. Next slide, please. So when using any of the documents we just covered, another important question is whether transfer risk assessment is needed. The CJEU's decision in the Schrems II case in July 2020, which invalidated the EU-US Privacy Shield, still applies in the UK as it was handed down pre-Brexit. As per this decision, when data is being transferred to a third country using an appropriate safeguard, additional measures may need to be put in place. This means that when relying on the EU SECs, carrying out a transfer risk assessment, or a TRA, will be a legal requirement. The TRA will allow the parties to assess whether the law and/or practices of the recipient country will impact the effectiveness of the safeguards provided by the EU SECs used to cover that transfer, and whether any supplementary measures must be put in place. Parties will also be required to carry out a TRA when relying on the IDTA or the UK Addendum to make a restricted transfer. When using the IDTA, the data exporter undertakes the TRA and provides a copy to the importer on request. However, when using the EU SECs, both parties will undertake this. Completing a TRA can be a complex exercise, and depending on the applicable regime, it may be risky to undertake data transfers where the TRA reveals a high level of risk. Next slide, please. So going forward, there are some key dates parties should be aware of. The first important date for the UK transfers was actually on 21st March 2022. From this date onwards, data exporters in the UK can start using the IDTA and the UK Addendum. The second important date for UK transfers is coming up on the 21st of September 2022. Up until this date, parties can still choose to use the old EU SCCs to cover new restricted transfers from the UK. However, new restricted transfers from the UK after this date will need to be covered by the IDTA or the new EU SCCs appended by the UK Addendum. Contracts concluded before this date, which include the old EU SCCs, will remain valid until 21st March 2024, unless processing operations under those contracts have changed. The next important date relates to EU transfers, and this is the 27th of December 2022. Contracts using the old EU SCCs to cover transfer of data from the EEA concluded before 27 September 2021, i.e. the date on which the old EU SCCs were repealed, will remain valid up until this date, provided that the processing operations haven't changed. And after this date, all EU transfers must be covered by the new EU SCCs. And finally, on 21st March 2024, the 2-year transition period will expire, and all restricted transfers of personal data from the UK will need to incorporate either the IDTA or the UK Addendum. We're also expecting some additional guidance from the ICO on the 2 new documents published by it, including a clause-by-clause guidance on the IDTA and the Addendum, and guidance on the transfer risk assessment. Any revisions to the IDTA or the UK Addendum made by the ICO in the future will also take effect automatically. However, the UK Addendum contains additional provisions which allow parties to choose termination, where any such revisions can cause a substantial, disproportionate and demonstrable increase in the party's costs and or risk. Next slide, please. So generally, this is an important time for the businesses to review their data flows, including any onward data transfers being made by their suppliers or sub-processors. It is important to identify where data transfers are being made to third countries and where you may be receiving data pursuant to a restricted transfer and which regime will apply to such transfers. The applicable regime will then also determine the documents we've covered above as to which ones should be used. And businesses should also identify which documents are currently being used in respect of data transfers and which ones will need to be updated or replaced. The above steps should be undertaken considering upcoming renewals or renegotiations of key contracts and allow for adequate time for new documents to be incorporated where necessary. It is also important to understand the key aspects of the new documents and see how these fit into your overall privacy and governance structure. Example, if you're receiving data, consider if you need to flow down any new requirements for onward transfers. There may be several moving parts involved in updating your documents and continue to making compliant data transfers, and it is important to understand all the relevant requirements. Unless there are any further questions, I will now hand over to Kolvin. Thank you.
Great, good morning, everyone. Thank you, Prachi. Next slide, please. So in this section of the webinar, I'll be looking at recent interesting enforcement actions, trends, and any lessons learned. So before we get into some of the specific actions, I think it's worth looking at where we see enforcement, and that's really in three main areas. So the sending of unsolicited communications, so sending text messages and emails without consent, or valid consent, breaches of the transparency requirements, so that's failing to give individuals the information that is required to be provided under the GDPR, and data breaches. So that is really failing to keep information safe. So what are the rules in this area? In terms of marketing, the unsolicited marketing by phone, fax, email, text, or other electronic messages is restricted. Now, there are different rules for different types of communications, but the rules are generally stricter when you're marketing to individuals as compared to marketing to companies. So you will need specific consent to send unsolicited direct marketing by email or by text. More of a sort of opt-out consent where marketing is done by phone, for example. And most of the enforcement activity is really focused around email and text because that tends to be the most intrusive due to the ability to send bulk text or in some cases millions of emails. So the threshold for obtaining valid consent is very high, and that was really changed in 2018 when the GDPR was implemented. And essentially, it means that consent must be knowingly and freely given, clear and specific. So it must cover both your particular organization and the type of communication you want to use. So you need to specify whether you're marketing by email or text. And you can't, because it needs to be specific to your particular organization, you can't obtain consent for third-party partners. You actually have to identify the organization who will be relying on the consent. It must also involve some form of very clear positive action. So, for example, ticking a box, clicking an icon, or sending an email. And the person must really understand that they are giving consent. So that goes to the sort of transparency issue and making sure that you're using clear and understandable language. And you cannot really show consent as part of your privacy notice. So burying consent language in a privacy notice isn't going to work. So the best way to obtain consent is really to ask the customer to tick an opt-in box confirming that they are happy to receive your marketing text or emails, and using very clear and specific language relative to that box. So in terms of transparency, individuals have the right to be informed about the collection and use of their personal data. So you need to provide individuals with various information, including the data you collect, how you use it, your retention periods, and ultimately who you share it with. So you must generally provide this information at the time that you collect their personal data. And typically, this is achieved via a privacy notice. That's relatively straightforward in the context of a website. Typically, you'll have one for your customers and your users, but also for your employees. And many people forget that they also need a notice in relation to their employees, and focus very much on the website privacy notice, when actually, the obligation implies in relation to data you collect from your employees. Now, in terms of the form of the notice, generally it needs to be concise, transparent, intelligible, easily accessible, and also to use clear and plain language. And that's not easy to achieve, and we'll see that in one of the cases that we will look at a little bit later. So getting the right to be informed is really fundamental to compliance with a number of obligations under the GDPR. So it is really a core principle around this concept of transparency. And it's particularly important when you are relying on consent as one of your lawful bases for processing. So lastly, looking at security. So this is a very key principle under the GDPR. As Nigel said, if there's one thing you need to do, it's to keep data secure, because there are a lot of quite severe consequences that ultimately will flow from that. So the GDPR says that ultimately you need to take appropriate technical and organizational measures to keep data secure. So it's very generic and high level, and it's intended to be so, and not specific. So ultimately, it's up to you to decide what that means in your particular situation. So you need to carry out a risk analysis, look at your organizational policies and physical security. So things like securing a building, securing equipment, and also technical measures like encryption. And as part of this assessment, you need to consider the state of the art. So that really means looking at leading security practices, and particularly practices in your particular industry, and the cost of implementation when deciding what measures to take. So whatever measures you ultimately end up implementing, they need to be appropriate both to your circumstances as a business and the risks that your processing poses. So the higher the risks and the greater your resources, the greater the expectation in terms of the measures you need to take. So if you're processing sensitive data like health data or data relating to ethnicity, then the obligations on you to keep that data secure are going to be greater. And one thing it's really important to look at is the use of pseudonymization and encryption. So generally, if you're not using encryption, you need a good reason, particularly if encryption is not expensive. So your measures must ensure that the confidentiality, integrity, and availability of your systems and services and the data that you process within that, and also that you're able to restore access and availability to personal data in a timely manner in the event of some incident. It's also worth noting that the ICO has a framework that it's developed with the National Security Centre to help you assess appropriate measures. It's relatively, I would say, kind of basic and entry level, but it's quite a good framework to at least assess your own security requirements by. So next slide, please. So turning to the enforcement activity, it's fair to say that over the last few years, we've seen an increase in enforcement activity, both in terms of the number of fines and the level. So in the UK, in 2021, the ICO imposed 32 monetary penalties compared to 17 in 2020 and only 1 in 2019. So far this year, there have been 18 monetary penalties. So the pace is slower to last year, which may be an indication of a shift in the priorities for the ICO and the new Information Commissioner, which I'll talk about shortly. The size of the penalties imposed has fallen quite significantly to those in late 2020 in the UK. When you look at data breaches involving British Airways and Marriott International, where the fines were in the tens of millions. Although, having said that, in May this year, Clearview were fined 7.5 million, but that's the only multi-million-pound fine issued by the UK in the last couple of years. This contrasts with the trend in the EU, where fines for breaches of the GDPR have increased markedly in 2021. In the last 12 months, fines have been announced of 225 million euros for WhatsApp and 750 million euros for Amazon. And in May this year, Google were fined 10 million euros. I think it's too early to say whether this is a trend demonstrating a kind of permanent shift in the approach by the ICO and a divergence in the approach from the UK regulator as compared to its EU counterparts. And I think we'll know more over time, but also when the ICO publishes its new regulatory action policy, which will really give us an indication of the ICO's approach and its priorities. So that's due to be published later this year. It's also worth noting the comments of the new Information Commissioner, John Edwards, who was appointed this year. Now he has a reputation for being business friendly, and this is part of the government's plan to make the UK a more business friendly environment in a post Brexit world. And in his first speech on the issue of fines, he said, fines are a slow way to find certainty. Instead, Edwards said that the view that he is forming is that the ICO's enforcement efforts must be used with surgical and targeted application. So I think that suggests that he doesn't see widespread fines as an effective way to drive compliance, and could mean we're likely to see an increase, or we're unlikely to see an increase in the use of monetary penalties. And I think the first part of the year, the pace of monetary penalties was at the same level as previous years, but since Edwards has become the ICO, that has definitely slowed. Having said that, I wouldn't rule out the ICO targeting high-profile businesses and marquee fines. So from Edwards' time as the data protection regulator in New Zealand, he was a frequent critic of big tech. So by that, Google, Facebook, WhatsApp, and I wouldn't rule out sort of him targeting those types of businesses with marquee fines in the same way actually that the EU regulators have done recently. So next slide, please. So on that note, the first case I want to look at is WhatsApp. So last autumn, WhatsApp was fined 220 million euros by the Irish Data Protection Commissioner for a number of failings relating to its compliance with the GDPR transparency requirements. So as I said, this is the requirement to provide individuals with information about the data you collect, how you use it, and ultimately what you're doing with their data. So this fine is the second highest under the GDPR, and I think sheds light on some of the key issues to be taken into account when drafting and updating privacy notice. So I think it's really important from a practical compliance perspective. Many of the practices for which WhatsApp was fined, I would say, are relatively standard. They're quite common in privacy notices that you typically find across multiple websites. So I think this case should herald some changes in the way that privacy notices are ultimately drafted and presented. Particularly with regards to the consumer businesses, consumer-facing businesses. So what are the lessons learned? So in particular, you should not use vague wording to explain your purposes for processing. Don't simply say you rely on legitimate interests to carry out a certain type of processing without actually mentioning what your interests are. So you need to be quite granular in setting out your business need in using the information. Don't use conditional language such as may when, for example, relying on or describing international transfers. So quite commonly we see we may transfer personal data internationally on the basis of certain contract on the basis of standard contractual clauses. So you need to be certain and say what you do. So saying that this is how you transfer data, and don't link excessively to external documents in your privacy notice, particularly where these duplicate or even worse, contradict information that's actually set out in your notice. So what the regulators don't want you to do, or what consumers shouldn't have to do, is to work hard to try and get to grips and understand the notice. So it really needs to be accessible and easy to follow. So much of the Irish Commissioner's decision focused on the way in which WhatsApp presented information in its privacy notice. So they identified numerous instances of overly complicated, unclear and inaccessible language that it would be really difficult for users to understand or follow. And I think what is clear from this case is that regulators expect you to be more granular and specific, so individuals are clear what is happening, but they also want notices to be concise and easy to read. So that is not easy to achieve, because there is a tension between giving full information and being granular, and at the same time trying to be concise and accessible. So next slide, please. So the other matter I'd like to mention relates to ransomware. So ransomware attacks are on the rise, especially with tensions between Russia and the West increasing. But we're seeing clients continually having to deal with ransomware attacks because it is a lucrative activity for cyber criminals. The National Security Centre has stated that ransomware is the biggest cyber threat facing the UK. So with this in mind, and recognizing the risks, that the risk is real for all businesses, large and small, it's important to understand how the ICO views ransomware attacks, because ultimately if you're you suffer a data breach, there are potentially reporting obligations to the ICO. You have to tell them about it. And in March, this happened to Tuckers, a criminal law firm, and they were fined £98,000 for failing to take appropriate measures to safeguard against a ransomware attack. So this was the first time the ICO has issued a fine relating to ransomware. And whilst Tuckers was a victim, this demonstrates that the ICO will not look kindly on organizations that fail to take appropriate measures to safeguard against a ransomware attack, because we all know that it's a threat, and ultimately the ICO expects you to be prepared for that and to take appropriate measures to mitigate the risks of that attack. So what happened? In the case of Tuckers, the attack resulted in the encryption of almost 1 million individual files, of which 25,000 were court bundles, so quite sensitive, relating to Tuckers' clients, and 60 court bundles were exfiltrated. Bear in mind, this is a criminal law firm, so it's going to be very sensitive data. 60 court bundles were exfiltrated by the attacker and then subsequently published on the dark web. And the ransomware attackers publish information on the dark web, sometimes for payment, and then ultimately sometimes for other criminals to use that information. So Tuckers ultimately had to report this matter to the ICO, and the ICO carried out an investigation, and they identified a number of security failures. And I think these failures serve as a helpful reminder of what is and isn't good practice. So firstly, there was a failure to appropriately manage vulnerability patches within Tuckers, i.e., not implementing patches in a timely manner to guard against known vulnerabilities. Tuckers took 4 months to implement a patch to fix the vulnerability that was the likely entry point for the attackers. So if ultimately that patch had been implemented, the attackers probably wouldn't be able to get into Tuckers' system. Secondly, they didn't use multi-factor authentication for remote access. So the remote environment is where the attackers operate. And the ICO considered that multi-factor authentication was a comparably low-cost preventative measure, which Tuckers should have implemented. So again, if you remember those rules, part of the assessment in terms of implementing measures is it low cost? Is it relatively freely available? And lastly, not using encryption, particularly as regards archived data. The ICO noted that the encryption of personal data may not have thwarted the attack, but it would have likely mitigated some of the risks associated with subsequent data exfiltration. And it was also a relevant factor that encryption is commonly used in the legal industry, but not by Tuckers. And that goes to the standards by which Tuckers were assessed by the ICO. So again, encryption was really key here. And ultimately, if they'd encrypted the data, ultimately the information would have been of no use to the attackers, and no use once published on the dark web. So following this case, the ICO published new guidance on ransomware attacks, which takes the form of a checklist for organizations to follow to ensure that they have sufficient protections in place against ransomware attacks. So it's absolutely worth sort of looking at that guidance, and it focuses on 2 requirements: technical controls to minimize the risk of an attack, things like multi-factor authentication, encryption, etc., and the policies and procedures that you need to have in place to react to an attack, such as incident response plans, disaster recovery, business continuity, etc. So I think the key takeaway from this is to review that guidance and update your technical controls and policies accordingly. And the Tuckers case really illustrates that the ICO is likely to have reference to its new guidance when determining whether firms have breached the GDPR and not having in place appropriate measures to guard against ransomware attacks. So I think we're at time, just about, and I'll hand back to Nigel just to close the webinar.
Thanks very much, Kolvin. We are just at time. I've just got a couple of seconds to answer a great question that we had from Luca, which was around international transfers, where the question is, isn't it the case that the transfers, all transfers of data to the US are restricted, given that US authorities may have the right to request all data held by a US firm, which is quite right. So, well, the transfers to the US are restricted in the sense that the US doesn't have the benefit of any adequacy decisions. So therefore, with regard to transfers to US, which is extremely common, one always has to look at how you can legitimize that. Typically, it will be done by standard contractual clauses or international data transfer agreement. But bearing in mind trends and what Prachi was saying about transfer impact assessments and supplementary measures, you have to wonder whether the US would be a safe jurisdiction anyway, because of the US government's ability through what's called their Foreign Intelligence Surveillance Act to technically get hold of all data that's being transferred. There is a European Data Protection Board paper on how to conduct this assessment. There's also a useful white paper that was issued by the US government, which says broadly they're not interested in day-to-day commercial information. So it is possible to construct, I believe, an impact assessment, depending on the sector you're in and so on, and whether you've had any experience of these things, to say that it's extremely unlikely that there would be any intelligence interest in your data. So again, comes down to standard contractual clauses, putting together a credible impact assessment and implementing any supplemental measures. Well, I pinched an extra minute to deal with that, but so I just want to bring us to a close. We've reached the end of our time, and I want to thank my colleagues, Prachi and Kolvin. Thank you for joining us. We hope you found it helpful. A quick reminder, if you've got any further questions, please do contact us by email. We would be more than happy to respond in the coming days. So thank you again, and wishing you a good day. Thank you.